Hello folks, it's Connie here from Nova Scotia. Hello Canada. I want to talk to you today about judicial immunity. Canada is under the divine right of kings. Even the words in the courtroom are straight from the definition of the divine right of kings when it comes to judicial and political immunity. Folks, what this means is that Canadian people have no rights in Canada because anybody, anywhere that complain about judges or politicians, any tribunal, any police commission, public complaints against the RCMP, they have immunity. So any complaint against these people is a total waste of time, which means we don't have our charter rights and there is no way they're going to be enforced. So folks, we are speaking out. We are going to change the system. If the courts won't uphold our rights, then we are going to uphold our rights by exposing the very violators who have committed crimes and harmed ordinary folks. I just want to read you a section from Wikipedia about judicial immunity. Judicial immunity is a form of legal immunity which protects judges and others employed by the judiciary from lawsuits brought against them for official conduct in office, no matter how incompetent, no matter how negligent or malicious such conduct might be, even if this conduct is in violation of statutes. For example, a judge may be the subject of a slander or libel suit for statements made about someone during a trial, or even if the defamatory statements had nothing to do with the trial at hand. Nor may a judge's clerk be sued for negligence in failing to deliver materials to the judge. The purpose of judicial immunity is twofold. It encourages judges to act in a fair and just manner, really, without regard to the possible extrinsic harms their acts may cause outside of the scope of their work. It protects government workers from harassment from those whose interests they might negatively affect. Really? Judicial immunity doesn't protect judges from suits stemming from administrative decisions made while off the bench, like hiring and firing decisions, but immunity generally does extend to all judicial decisions in which the judge has proper jurisdiction, even if a decision is made with corrupt or malicious intent. Corrupt or malicious intent. Note, however, that while the judiciary may be immune from lawsuits involving their actions, they may still be subject to criminal prosecutions. They don't. For example, when West Virginia Judge Trocy became irritated with a rude defendant, he stepped down from the bench, took off his robe, and bit the defendant on the nose. He spent 5 days in jail and was put on probation. Well, that's probably an extreme example in the United States, but certainly in Canada, you can't prosecute a judge. Historically, judicial immunity was associated with the English common law idea that the king can do no wrong. Judges, the king's delegates, for dispensing justice, accordingly, ought not to be drawn into the question for any supposed corruption, for this tends to the slander of the justice of the king. This is what we have today, and I'm going to read you a small section of the Charter of Rights, section 24, which basically upholds this immunity, and it says, wait a minute, it's not 24. This is section 24.2, enforcement of the Charter. Where in proceedings under subsection 1 a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by this charter, the evidence shall be excluded if it is established that, having regard to all the circumstances, the admission of it in the proceedings would bring, here it is, wait for it, the administration of justice into disrepute. And that's what the courts use every time they don't want to prosecute anybody that has blanket immunity. It would bring the administration of justice into disrepute. They use it in the courts. I've heard it many times. And it's right there. So, Canada has a blanket immunity for all judges, lawyers, prosecutors, Canadian Judicial Council, the Human Rights Commission, police and police chiefs, and police commissions, public complaints against the RCMP. They're all immune. And that's why they never charge themselves. You will never find a police tribunal that says, oh yes, these people did wrong and they will be charged. You will never find a court that says, oh yes, this judge did wrong and he will be arrested, even though they've committed crimes like fraud, theft, extortion, abducting children, parental alienation, and kidnapping. Maybe not kidnapping, but abducting children and allowing it to happen by giving them their courtly rubber stamp to kidnapping infants and children away from their parents. Just another day in the life of Canada, folks. Connie out.